In that light, Ms. Eckelbrett, did you hear the president say there was not a smidgen of corruption?
I've heard that he said that, yes, sir.
Ms. Garrison, did you hear the president say there was not a smidgen of corruption? And let me just translate that, because smidgen's not a legal term. I assume he meant scintilla, and I assume he meant criminality instead of corruption. How was he able to make that conclusion? Neither of you have been interviewed by the Bureau, have you?
No, sir.
And according to Mr. Sekulow, of his 41 clients, 3 have been interviewed, or 3 were asked to be interviewed.
Right. Not interviewed yet.
Okay. 0 of 41 have actually been interviewed.
Correct.
All right. So the president says there's not a smidgen of criminality or corruption. Do either of you remember seeing a witness named Lois Lerner sitting at the very table y'all are sitting at? Do you remember her invoking her Fifth Amendment privilege, the same privilege that she targeted some of your groups for trying to educate people about? Some of your groups just want to simply educate people about the Constitution, the one that she availed herself of the very second she was exposed to criminal investigation. So how can the president say there's not a smidgen of criminality when Lois Lerner invoked the Fifth Amendment? 41 witnesses haven't been interviewed, including the 2 that are here right now. How can he possibly draw that conclusion?
Good question.
I wish one of the colleagues on the other side of the aisle would ask the president how in the world he concluded no criminality when Lois Lerner sat in front of them and invoked her privilege against criminality. How do you square that?
Mr. Gowdy, if I may, she invoked her Fifth Amendment privilege, which she has the right to do, of course, and you and I both respect that, because we now know the reason why. It wasn't perhaps as clear as it was made yesterday. She invoked her Fifth Amendment privilege because she knew, after she made a false statement and a planted question at an ABA meeting, she knew that, in fact, there was her words and her emails, off-plan drafting of rules targeting conservative groups. She also said at a Duke Law Forum that people are asking us what we can do, and she said, I can't do anything until I see the 990s, the tax returns that are filed. That was all going on while she was redrafting the rules with the highest level of the Chief Counsel's office. Mr. Cartwright.
Mr. Sekulow,
yes,
I want to say this. I understand why she invoked her Fifth Amendment privilege. I don't understand why in the hell the President of the United States would prejudge an investigation before any of your clients were interviewed, before either of these 2 victims, and I know you don't like that word, but I'm using it in the criminal sense of the word, before either of these 2 victims were interviewed. He has gone on national television. He has prejudged the investigation, and in my judgment has compromised the Department of Justice, which leads me to this question, Mr. Sekulow.
Yes, sir.
There is the option, when you have a compromised investigation and a chief executive who has prejudged the outcome before the jury's even gotten all the evidence, he's got an option of appointing a special counsel, right?
Yes, he does.
And the special counsel regulation says if it's extraordinary circumstances that furthers the public interest. Can you think of anything more extraordinary than government targeting people based on their political beliefs?
No.